Good morning. We'll go ahead and get started. I'm Andrew Bell. I'm a resident ethics fellow here at the Stockdale Center. It's a distinct pleasure and honor to introduce a very distinguished panel that we have with us today. On my left, we'll start with Professor Mitt Regan, who is the McDevitt Professor of Jurisprudence at the Georgetown University Law Center, as well as being a senior fellow for ethics here at the Stockdale Center this year. And to my immediate left is Professor Rosa Brooks, who is also Professor of Law at the Georgetown University Law Center, as well as an Associate Dean. In addition, she recently served as the as the counselor to the Undersecretary of Defense for Policy in the Obama administration, and additionally published last year a very well-regarded book that relates to our topic today on how everything became war and the military became everything. So we have a distinct privilege to listen to their thoughts today. I won't take much longer, but afterwards we'll welcome your questions, and we'll try to wrap up by about 12:30 so we can get on to lunch. So.
All right. Thank you, Andrew. It's a real pleasure to be here again this year at this wonderful event. And I'm going to be talking about just one of the many kinds of challenges that Rosa talks about in her book that relate to the nature of modern conflict and modern security threats, and that is the movement away from simply traditional state versus state armed conflict. And as we know, a fundamental principle of both legal and moral norms in armed conflict is the distinction between combatants who can be attacked at any time and civilians who can't. We stipulate that uniformed members of state armed forces basically pose an ongoing threat. Right? There is a practical simplicity to this distinction, but an implicit moral basis, I think, is that people should be subject to deadly force only if they bear some responsibility for posing a serious threat. And the assumption is that people who voluntarily agree to join the military agree to join an enterprise that, as Samuel Huntington put it, is involved in the management of violence. Now, identifying which non-state actors, not in uniform typically, can be attacked, however, requires a more individualized assessment of who bears responsibility for posing a threat. Right? So it creates a distinctive challenge that we don't face in traditional state versus state conflicts. One way to frame this is that we attempt to make a determination of which persons have hostile intent. Right? One approach is to say that all non-state actors are civilians who can be attacked only while directly participating in hostilities, which is when their hostile intent is most clear. Right? Another approach, however, adopted by the International Committee of the Red Cross in the U.S. is to try to identify those non-state actors who are the equivalent of soldiers in uniform because they regularly participate in hostilities on behalf of the equivalent of a non-state army. Right? And so the International Committee of the Red Cross has adopted an influential approach to this, which says that these non-state persons are those who are members of non-state organized armed groups. These are the equivalent of uniform state soldiers, right? And the ICRC says that these are people who are engaged in what they call a continuous combat function. Right? So what is that? That means that, as you can see, they're involved in the preparation, execution, or command of acts or operations amounting to direct participation in hostilities. Right? That basically means leaders who plan and coordinate hostile operations and persons who directly carry them out. Right? This does not include people who engage in what the ICRC regards as support functions. Right? Only those people who regularly plan hostilities and directly carry them out are in a position, as the ICRC puts it, engaging directly in hostilities. They're bringing about harm by virtue of one causal step. So essentially what the ICRC does is distinguish between, you can think of sort of combat personnel and support personnel, and say only those people in the former category can be targeted at any time, because we can be most confident about their hostile intent given the nature of the activities in which they're engaged, right? And I think it's also fair to say that implicit rationale for this distinction from the ICRC's perspective is that it can be difficult to identify non-state actors, right, who are the equivalent of uniformed military personnel, and there is a risk that persons who are traditionally regarded as protected citizens may erroneously be designated as such by virtue of interpretations of their behavior. We should therefore treat as a combatant those for whom there is strong evidence of hostile intent. Not everyone who contributes in some way to military activities has the type of intent to cause harm that's morally sufficient to justify subjecting them to deadly attack. Now, the difficulty with the ICRC standard, right, notwithstanding its virtues, is that when applied to terrorist organizations, the ability of these organizations to carry out their operations often is crucially dependent on people who fit into neither of the ICRC categories, right? This is because most terrorist groups are organized not as conventional, integrated, hierarchical organizations, but as networks, right? Now, you don't have to worry about reading the text on this. This is an actual depiction of a terrorist network. And as it illustrates, terrorist networks consist of a large number of relatively isolated cells that are only loosely connected to one another, and only connected to leadership through a few key what are called nodes, channels of information that connect disparate parts of the network to people in higher positions, right? This loosely coupled network structure reflects the paramount need of what are called dark networks, such as these, to remain secret and avoid detection, right? An integrated, tightly coupled organization is vulnerable to detection because flows of communication in such an organization potentially can enable an outsider to identify all relevant actors, moving all the way up the chain and bringing the organization down, okay? Now, unlike a conventional military organization, it is not the case in a terrorist network that leadership issues instructions that are then executed by operational units. Rather, individual cells often have a general desire to be involved in some way, right, but lack the connection with leadership that gives them the resources and the guidance they need to carry out those intentions. Similarly, leadership may have broad strategic aspirations, but they lack the connection with people who have the commitment and knowledge of local conditions to help them realize those aspirations. So in order to meet its goals, a terrorist organization has to solve the challenge of connecting leadership and cells on an ongoing basis without the benefit of conventional organizational structures of communication and authority. Networks provide decentralized cells whose members have minimal knowledge of the overall network, and their connection to the network often consists of interaction with a single person who serves as a node through which communications from the cell are transmitted to another person who has ties to higher-ranking persons in the network, who in turn may be able to provide resources that the cell needs. An example of one kind of node is what three scholars call Al-Qaeda's middle managers. As the authors put it, middle managers are crucial in enabling the flow of information, resources, skills, and strategic direction between the top and the bottom of the organization. If middle management is removed, the top leadership lack the reach and opportunities for implementing their global designs. The grassroots may have great intentions, but will fail to acquire the needed resources to carry out effective campaigns. Right? In addition, nodes such as couriers may serve as the only channel of communication among mid and upper level leaders of the network in different regions or who perform different functions. So the non-state terrorist network operates quite differently from a state armed force. In the state armed force, those who plan and command operations and those who carry them out, the leaders and the soldiers, so to speak, apologies to the Marines in the room, are closely linked through organizational protocols in a hierarchical organization. Soldiers essentially are assets under the control and direction of leadership who deploy them in accordance with strategic directives. By contrast, the effective functioning of a network depends crucially on nodes that can connect different points of the network. And as you can see there are some dots, nodes, in which there are a number of intersecting channels of communication. Right? Now, it's important to realize that nodes are not interchangeable, fungible components of a network. Because of their crucial function in a network that seeks to avoid detection, they must have the trust, the absolute trust of key members in the network. So, for instance, a courier's ability to serve as a link between leaders in two regions will depend upon the trust that each leader has in that particular individual. So you can't simply remove someone, as you could say in a bureaucratic organization, insert someone else who has the same job skills and job title, and the organization then can continue to function. So nodes in a terrorist network represent what one scholar calls the hub of all power and movement on which everything depends. Now, social network analysis, such as this, is a way of organizing data on patterns of information among disparate individuals who have no formal membership status in order to depict their interactions as a network with various nodes. And there are ways that you can calculate the relative importance of nodes within a network. One is called Eigenvector Centrality, some of you may know. It's a measure of the number of connections that a node has to other persons in the network weighted by the number of connections that those other persons had. Right? So we get degrees of centrality, so to speak. Now, because of their importance, removing a node from a terrorist network may disrupt it more than decapitation of leadership or strikes against operational cells. Right? As a couple of these quotes from scholars indicate, right? By striking basically at middle management or couriers, right, you can severely disrupt a network, right? Now, the difficulty is that these sorts of people typically don't fall within the categories that the ICRC regards as people continuously engaged in a combat function, right? First, many perform their function only periodically, not continuously, when the need arises. Otherwise, a node may be involved in civilian work. One important al-Qaeda node identified in one study, for instance, works as a taxi driver and a chef. In addition, they're not engaged either in planning specific operations nor in carrying them out. Right? They provide what the ICRC regards as support for the general war effort that enhances the capability of the organization or the network, but that doesn't constitute direct participation in hostilities. So these are people who could not be targeted as combatants under the ICRC standard, right, unless they're directly participating in a particular hostile operation. Right? Now, by contrast with the ICRC, the United States takes a more expansive approach to defining who's part of an organized armed group. It basically takes the position that sufficient ongoing participation in and support of a group can justify characterizing someone as a member of the group who can be targeted at any time, regardless of the particular function that they play. So that doesn't distinguish between a combat function and a support function. Right? The U.S. position is that the integration of the person into the armed group basically provides an inference that the individual shares the group intention to commit hostile acts. So, in essence, the U.S. regards continuing ongoing involvement as the basis for inferring hostile intent. So the U.S. basically agrees with the ICRC that it's hostile intent that distinguishes a combatant from a civilian, right? They just adopt a more expansive view of what sort of behavior can be the basis for inferring hostile intent, right? And so the more expansive U.S. definition of who's a member of an organized armed group would permit an attack on a person whom social network analysis has identified as a key node in a terrorist network. Okay? So in closing, I just want to raise a couple of potential issues or concerns, which I certainly haven't resolved, but I'm hoping you will. Right? One is that networks do not exist in the world in the same way as physical armed forces do. They are analytical constructions based on analysis of data, the application of certain social science techniques, right? And the people who create these maps of networks are not disinterested in the activities, obviously, that they're analyzing, right? To identify someone as a node in a network and subject him to lethal targeting by virtue of that status as a node is not the same as identifying a member of a state armed force who has a recognizable function and whose activity is integrated with the activity of others in the organization. Right? So what occurs is that through the generation of various analytical frameworks by analyzing data, right, you then assign status as a combatant, right, which means that someone can be targeted at any time. Right? But these are, echoing David Lubon to some extent, right, these are human beings constructing these models, and they can be very difficult to construct an interpretation. So again, we've got much more ambiguity in defining someone who's a combatant in a non-state group as opposed to state armed forces, of course. A second potential concern is the possibility that in some cases targeting on this basis may sever the connection between liability to deadly force and moral responsibility. In some cases, targeting a node may be consistent with the imputation of moral responsibility based on hostile intent. Right? In other words, some hubs or nodes may be aware that they're a node in a broader network. That is, they may know they're one of a number of very small persons through whom communications pass. They may know the purpose of those communications. Right? In other cases, however, a node may not know he is a node. Right? He may have only limited knowledge of what someone does to whom he refers someone else. As an intelligence official described the activity of al-Qaeda couriers, al-Qaeda has people who met people they didn't know to deliver a message to another person they didn't know, and eventually it worked its way up to top leadership. So in such cases, a courier may play a vital role in connecting portions of the network to one another and thereby enabling the terrorist network to achieve its goals. But he may not know the content of the message he's delivering, the role of the person to whom he's delivering it. He may be, for instance, doing a favor for his cousin who says, I need you to get this information to someone else, right? In other words, they don't necessarily, in every case, know the full implications of the activity in which they're engaged. And yet, by virtue of their location within the network, not their state of mind, but their location within the network, they play a crucial role in contributing to the success of the terrorist organization. So in these cases, we can say someone makes an important causal contribution to the group's ability to conduct hostilities, yet he himself may be only vaguely aware of this, so that if he is subject to attack, It's not so much because he has hostile intent in any robust moral sense of the term. It's more plausible to say that it's because he makes an important causal contribution to hostilities, even though he himself may be unaware of that. It is not his conduct in itself that subjects him to deadly force, but it's the fact that that conduct occurs by someone in his location within the network. Okay? So there are a lot of debates about the bases, the extent, the nature of moral responsibility that subjects someone to deadly force, which I won't reprise here. But I just want to say in closing that social network analysis has the potential to make non-state dark networks more transparent and illuminate their operations. At the same time, because those networks draw on a diverse group of non-uniform persons for various resources, those terrorist organizations, basing targeting decisions on network topography, if you will, may challenge our notions of the basis for liability to legal force. Thanks very much.
Thank you, Mitt. Fascinating remarks, and now we'll hear from Professor Brooks.
Great, thank you very much, and I'm very grateful to the Stockdale Center for hosting this and letting me be part of it. I'm also very delighted to have so many of my Georgetown law colleagues on the conference agenda with me. I don't have a PowerPoint. Despite having spent a few years at the Pentagon, I never really got the PowerPoint bug. I was briefly famous within my circle in the Pentagon for having put a picture of Tinkerbell in a PowerPoint that I was going to give to the chairman of Joint Staff, and one of his aides said, "You can't give the chairman a picture of Tinkerbell." And I said, "Why not?" And he said, "You have a lot to learn about the military." And I said, "No, it would be very good for the chairman to get a picture of Tinkerbell." But that was so emotionally scarring to me that I decided I better not do any more PowerPoint. I would just talk from now on. So I thought I would talk about what you might call the legal challenges associated with gray zone conflict, gray zone and really hybrid conflict in general. But and I know it's become kind of a buzzword. We talk about gray zone conflict, and everybody's trying to figure out, well, is that really a thing? What is that thing that this thing is? Is hybrid warfare really a thing? If so, is that thing the same thing as gray zone conflict? I don't really care about those issues that much, but I'm going to assume that it's a thing and talk about the ways in which the thing that it is, whatever it is, challenges particularly our international legal framework. Let me start by just making a general point about law, which on some level is obvious, and you all know it already. You know, to make law is to make categories, and to interpret law is to assign actors, actions, events into different categories. You know, we talk about, when you talk about theft, for instance, that means, you know, to have a concept of theft means you have to have a concept of property. And when we decide whether something was theft or just borrowing or accidental, you know, we have to know what these categories mean. We have to have some kind of collective understanding of what these categories mean. Otherwise, they just don't work. And the same is true for all of our categories associated with the legal framework that relates to coercion and the use of armed force, right? And you all know what those categories are, right? We have categories war and peace, military and civilian, foreign and domestic, public and private, emergencies and normality. We have subcategories that relate to, we have some concept of, there's something that we call use of force. There's something we call force. We have something we call an armed attack, hostilities, participation in hostilities, combatant, et cetera, et cetera. In order to apply the law in a coherent sense, we obviously, these things have to have some shared meaning. We need to know what they mean. And a lot hinges on our ability to do that. Knowing what these categories mean and knowing where to put different things, basically, you know, to put it bluntly, our ability to apply those categories and concepts in a kind of coherent, predictable, principled way is the difference between legal and illegal. It's the difference between getting a medal and being put on trial for war crimes. If we think that the targets of U.S. drone strikes in Yemen or Pakistan or wherever outside of a hot battlefield are combatants in an armed conflict between the U.S. and al-Qaeda and its associated forces, and we think that the people we're targeting are legal targets, either they're combatants, enemy combatants, or they're civilians who are participating in hostilities, as Mitt just discussed, well then there is no moral or legal difference between the U.S. targeting, killing those people in a drone strike or special operations raid. There's no legal and moral difference between that and an American soldier on the beach of Normandy on D-Day shooting at a German machine gunner. They're identical legally and morally if we think we've got our categories right. If we think our categories are wrong, if we think, oh, wait a second, I'm not sure there's an armed conflict over there, or I'm not sure that person's a combatant, or it's not, or is maybe participating in hostilities if a civilian. If we get it wrong, then we're murdering people, right? And we really want to know the difference for obvious reasons. It's really important to us to be able to know the difference. All these categories have always been contested on the margins, at least. There have always been guerrillas and partisans and proxy wars and so forth. And I think, obviously, states and other actors have always made use of non-kinetic means of asserting influence and control. They've always used espionage, economic pressure, sanctions, propaganda, you name it. There's nothing new about that. And so in that sense, what we today tend to call gray zone warfare isn't particularly new, or hybrid warfare, that actors in armed conflicts have always done whatever they can with all the means at their disposal to achieve their ends. But I think it's probably fair to say that technological changes of the last few decades have, in fact, put us at a place where instead of just happening on the margins, that kind of stuff is now becoming more and more central to what we think of as armed conflicts. And you know what I'm talking about, and you've been talking about it for the last 2 days. Technological changes in communication and transportation that leads to increased global connectedness, interconnectedness, which in turn creates new vulnerabilities for states. The rise of the distribution of lethal technologies, which has given non-state actors and even individuals the ability to cause harm and mayhem, both physical destruction and instability on a level that we traditionally associate with states. States obviously facing more and more competition when it comes to the use of violence. We've also seen violence itself is facing more and more competition from non-kinetic means of asserting influence and control. And here, remember Clausewitz. Clausewitz defined war as an act of violence to compel our opponent to fulfill our will. But today, increasingly, both states and non-state actors can achieve war's traditional ends using means that are not themselves violent, which throws into doubt even our whole category of war. Clausewitz also, of course, famously said that war is politics by other means. But to say that war is politics by other means, that war has a political objective, is also to say, by implication, that war is not the same as politics, that war is a particular means. It is a violent means of achieving your political ends. And that's why traditionally we don't think of economic sanctions or, as war. We don't think of a game of chess as war, et cetera, et cetera. So today, needless to say, as we've been discussing all day, it's just getting harder and harder to figure out how to apply any of our basic categories in a way that makes any sense whatsoever. When we talk about wars on terrorism or a cyber war, almost by definition, you can't have any boundaries in either space or in time. You can't say, aha, there's the battlefield. You can't say, clearly this war began at this moment, people don't declare it, and it will end with a formal treaty surrender or something like that. We don't know who the enemy is. And I think Mitt just gave a great explanation of why not only do we not necessarily know who the enemy is, we can't always even name an organization, but we don't quite know what it means to be a combatant anymore or to be participating in hostilities. Our models, our categories are all created on the presumption that you can tell who an enemy combatant is because he's going to be conveniently wearing a uniform that says enemy combatant on it, or some equivalent of that, right? We don't know what a weapon is. On September 11th, 2001, the weapons were cheap box cutters you could buy for a few dollars at CVS, and civilian jet planes. Today, we increasingly think that a line of malicious computer code could be a weapon. We think of it in terms of weapons, or a financial instrument of some sort, or a bioengineered virus could be a weapon. We don't know what a civilian is. We don't know what hostilities are. So across the board, I think it is fair to say that we have entered an era, and needless to say, by the way, the good old-fashioned bloody violent warfare continues too, right? I mean, look at Syria today. We're actors, we humans are still using good old-fashioned brute force to achieve our political ends, but increasingly we see this larger and larger overlay of kinds of methods of coercion and control that don't fit neatly into our categories and that really confound our ability to make these crucial judgments about what counts as a war, who counts as a combatant, et cetera, et cetera. And of course, needless to say, if you don't know what counts as a war or what counts as an armed attack or a use of force, then all of our law and ethics for armed conflict kind of go out the window because we're so dependent on our ability to put things in those categories. Why do states and other actors like gray zone warfare? Well, because, and I think David Luban alluded to this, often lawyers like ambiguity, and political leaders like ambiguity. The beauty of gray zone activities, if you're a state, is precisely that you can exploit these uncertainties and ambiguities in order to evade legal responsibility and minimize military, economic, and political consequences. So you're a Russian hacker, or you are the Russian government, for that matter, and you want to mount an influence campaign that affects the U.S. election. You can stay just below the level at which it is possible for us to have definitive attribution that persuades the entire international community and therefore triggers a decisive response. If you're China and you have your Coast Guard and your private fishing vessels going a little too close to U.S. military ships in a way that is clearly provocative, and you're building your little islands, again, you're just below the level at which it is easy and clear to say, hey, these are hostile acts. This could trigger a conflict because we're pretty sure, but we're not quite sure about attribution. It's kind of hostile, but it's not totally overtly hostile. So how do we judge it? The more you can sow confusion about attribution and responsibility, the more you can minimize the likelihood that there will be prompt or decisive and unambiguous consequences. The U.S., as we know, is not always so good at this. We often struggle to figure out how to respond to the gray zone activities of other actors, whether they be states or non-state actors. And I think many have remarked that it's, here authoritarian states, the Russias and Chinas, or non-state actors that don't care about things like human rights or democratic accountability, have a built-in advantage because the nature of gray zone activity is that you're merging public and private means, you're merging military and non-military, and we here in the United States and most other democracies have tied ourselves up in various knots for all kinds of really good reasons that prevent us from doing that easily or well. And our own accountability structures and democratic structures make it a lot harder for us to move in a centralized and decisive way. I think that's true, and we still have a lot to learn about how to respond. But I also think we tend to forget, because we think of ourselves, we're the good guys, we tend to forget that the U.S. has also been a gray zone warfare pioneer in its own way. And here I'm thinking of, during the Bush administration, for instance, the Bush administration, after the September 11th attacks, very consciously exploited the gaps and ambiguities in the law of armed conflict to maximize its freedom of action in a way that would minimize international consequences, e.g., the early claim, for instance, that neither al-Qaeda nor the Taliban was in any way covered by the Geneva Conventions at all. Some of the legal game playing that went on to justify what prior to then, and I hope now again, is clearly considered torture under international law, and some of the rules on detention and so forth. These were carefully calibrated to bypass standard international law restrictions while superficially maintaining legal compliance. You know, you could say with a straight face, well, there's a gap or an ambiguity and we're compliant with the law, and it mutes the international response. And the Obama administration and now the Trump administration have really done the same thing. And I think that US targeted strikes are a case in point, that we have played pretty fast and loose with jus ad bellum rules when it comes both to target strikes, well, and frankly, things like the Syria strike most recently, somewhat different case, but where we have sort of squished together jus ad bellum and jus in bello in murky and confusing ways. And at the end of the day, we've also said with regard to most of our targeted strikes outside traditional areas of active hostilities, we've said, we would love to give you the details that explain exactly why this is completely lawful, but unfortunately, it's classified, it has to remain classified, can't give away sources and methods, can't tell the terrorists how we knew who they were, can't tell you who they are, can't tell you why we targeted them, so just trust us. And that, too, is a way, it's a form of gray zone warfare, right? It's a way of exploiting the uncertainties, gaps, vagueness, and ambiguities of the legal framework to say, to do something that otherwise might be condemned and lead to a decisive international response of one sort or another. So these gray zone activities, I think, clearly do offer states some short-term benefits in terms of freedom of action. But I also think that whether it's the US doing it or whether it's other actors doing it, that particularly when states engage in gray zone warfare, it also presents very significant challenges to what you might call the international rule of law or the rule-based international order. And that's not because any of these activities clearly violate international law. On the contrary, they would be less threatening in some ways to the international order if they did clearly violate the law, right? The state violates the law, other states say, hey, you violated the law, stop that. The offending state either stops it or gets punished in some way. Even if it doesn't get punished because it's too powerful, other states have clarified the norm. Even by saying, hey, you violated the norm, it gets clarified, and everybody goes home at least more or less happy at the end of the day. But precisely because gray zone activities defy that kind of straightforward legal categorization is the reason that they are so challenging and undermining to the rule-based international order. And indeed, I think you could say that, collectively, they amount to a serious and sustained attack on the once widely accepted meanings of these core concepts that our law, domestic and international, depends upon. I should also say that, up to a point, vagueness and ambiguity can be good, particularly in the international legal system. You don't have a Supreme Court, you don't have an executive branch, you don't have an army or police force to enforce the law. So up to a point, you want some degree of vagueness and ambiguity. It lets states save face when there's a dispute. It lets the law evolve in various ways. It lets everybody kind of have ways to back out of conflict sometimes. But at the same time, obviously, beyond a certain point, vagueness and ambiguity in any legal system just becomes crippling. When consensus on basic categories and concepts breaks down completely, it becomes harder and harder to get any sort of international consensus on how to evaluate state behavior. And as a result, it becomes harder and harder to predict state behavior, because when states don't know what the international response will be to their actions, when states don't know how other states are likely to interpret the rules, when you go from a little bit of uncertainty on the margin to sort of radical uncertainty at the center, and you don't know anything, what on earth will Russia do? What does Russia think is okay? We don't know. Russia looks at us, frankly, I think, with the same degree of uncertainty. What exactly does the U.S. think that the rules are? How will the U.S. respond to what we do? Then you get a pretty dangerous situation of instability, because fundamentally that's what we want from our international order, just as that's what we want from our domestic legal system. We want to know what the rules are. We want reasonable predictability about how others are going to act. We don't need everybody to follow all the rules all the time, but we need to know what they are, and we need others to follow them enough of the time and to be punished enough of the time if they don't, that we can kind of go about our daily lives and make contracts and go to school and go to work, and if you're a state, participate in your normal state activities. When you lose that, you get problems. You get instability, and you get a potential for escalation. So just as here's the glass half full, here's why states like gray zone warfare, is because you can exploit that ambiguity to stay just below the level that will trigger a decisive response. But when those categories and concepts break down, increasingly you're not quite sure what incremental next step will trigger what will be the straw that breaks the camel's back when it comes to Russian influence activities or Chinese gamesmanship in the South China Sea, or for that matter, U.S. action. What is that a state may think to itself, oh, hey, I've been able to get away with this, and this, why not add this one more little tiny thing? And that little tiny thing could be the thing that triggers a decisive response, but we don't know what that thing will be anymore. And I think replacing an era in which there was a clearer sense of where the red lines were, of here's what you can get away with, Russia or US, in proxy warfare, et cetera, here's what you pretty clearly can't. And that zone in which we're not quite sure has just expanded dramatically. So what do we do about this? I think that when we talk about gray zone warfare, we have a tendency to talk about it in a sort of tactical, operational sense. And I've been part of many of those conversations, and we say things like, aha, we need to build better counter capabilities. We need to do better as the United States at also acting in the gray zone. And that's probably, to some extent, that's probably right. But as Michael Mazar has argued, he says the most important U.S. answer to gray zone tactics is not to build a whole suite of counter capabilities, such as fishing fleets or our own battalions of little green men or propaganda campaigns. He says, some of that would surely be useful for the U.S., which tends to be, we tend to like our conventional methods and be a little loath to really break out of them. But he argues that adversary gray zone campaigns are most likely to fail when they cannot sneak under the radar of the international system. Thus, the most important and ultimately effective response will ultimately be to reaffirm and strengthen the norms, rules, and institutions of the international order in ways that will render other states' gray zone campaigns even more provocative and self-defeating than they already are. So what does that mean? I don't think that means that the U.S. should just revert to championing sort of traditional formalist conceptions of international law. On the contrary, the proliferation of these gray zone challenges is itself testament, I think, to the weaknesses of the post-World War II legal order and the anachronistic nature of some of the categories that we're working with. The U.S. and other actors are not wrong to argue that these binary categories aren't doing a whole lot for us these days. But I think our challenge in the years to come will be to envision and ultimately to help create a more equitable and more inclusive rule-based world order, one that has more effective collective problem-solving mechanisms and dispute resolution and accountability mechanisms built into it. And that's going to be hard. It's going to be the work of generations, not the work of the next presidential administration or the one after that or even the one after that. And it's going to require a commitment to working collaboratively both with our allies and with our adversaries, and a commitment to thinking about creative ways to bring in those non-state actors that are willing to be brought in as participants in the process of designing and implementing some sort of new order, to develop appropriate and transparent rules for that space between war and peace. For cyber conduct, to ensure accountability and uses of force against non-state actors, against networks, against contractors, against other private actors, rules, transparent and clear rules for the use of non-kinetic forms of coercion and control that don't fit neatly into our existing legal categories. Am I optimistic? In a sort of the long arc of history, yes, I am, in fact. I think sort of you take the long view of human history, the last 500 or so years, has been, to paraphrase Martin Luther King, and, an arc towards greater transparency, greater recognition of the importance of individual human beings and their lives, greater accountability for the powerful. And I think that we're continuing to move in that direction. In the long run, I feel optimistic because we human beings have radically reinvented the international order multiple times before, most recently and in the lifetime of people we know. Of course, after World War II, we radically reshaped the international legal and institutional order in a manner that was designed to make it more predictable and more respectful of individuals. We did it in the lifetime of people we know. We can do it again. When I'm feeling less optimistic, I remind myself that historically, the major reshapings and radical reimaginings of the global order have tended to occur only after catastrophes. The 30 Years' War brought us the Peace of Westphalia and the Westphalian system that evolved into modern international law, and our wonderful post-World War II legal order, now getting awfully long in the teeth, came to us only after 2 catastrophic world wars. So I hope that it will not take another catastrophe to impel us to design the next system, the one that will work better in the decades and centuries to come.
Professor Regan, Professor Brooks, those are really fantastic and very insightful comments. So we'll take a few minutes just before lunchtime to take some questions. Start over here. Yes, Dr. Gross.
Thank you. Mitt, I wanted to go back to some of your comments you made about social network analysis. For me, very informative. I wasn't that familiar with it. 3 related questions. The first of all, you talk mostly about Al-Qaeda and organizations with dark networks. To what extent does your analysis apply to more sophisticated guerrilla organizations that have well-developed political and military wings, like Hezbollah, like Taliban, going back a little further, like those in East Timor and Kosovo, where you had a very sophisticated political wing that assumed many of these intermediate functions. Now, you may have sleepers and sleeper cells and things, but by and large, a lot of these support functions were provided by a political wing. So then the second question is would this political wing, which might show no hostile intent, but certainly provide important causal contributions, would they then be targetable? And if so, can you turn the model around and say, well, what about non-states living in states? So you've got Hamas out there doing social network analysis, and they do their analysis, and they find out that Gross teaches Israeli naval cadets, which I do, and who hopes to make an important causal contribution, which I do hope to. Am I then targeted? And so where does it go in the end? Put it out in that manner.
Michael, I think you put your finger on a crucial question. That is what led the ICRC to try to draw the boundaries fairly narrow, because implicitly, at least, they say there are a whole range of people in and outside of uniform, if you will, look at state actors, who make a causal contribution in some way to the ultimate achievement of military objectives. Right? And so what they did when trying to fashion their standard was to say, well, you don't want to open the door to the possibility that, first of all, we're talking about people, at least formally, international law, who are presumptively civilians, right? Because they're not members of state armed forces. Right? The question then is, can we find the equivalent of people who are wearing uniforms, even though they don't? Right? And so they say, the reason they exclude everyone other than those who are directly involved in some way, as they define it, in hostilities, is because there is a whole spectrum of kinds of contributions that people can make. So if, going back to my point, if we move away from what we think of as some sort of at least robust notion of moral responsibility for posing a threat to simply causal contribution, right? It's difficult to know exactly where to stop. And, some of you may be familiar that the revisionists, the revisionist just war theorists, particularly Helen Froese in her most recent book, basically says that civilians should be targetable in some cases, civilians on the unjust side. Right? So it's an effort, going back to Rosa's point, if you haven't read her book, I urge you to do it. We're now bereft of conventional boundaries, and so in attempting to draw boundaries under much more ambiguous circumstances, there may be these implications that we really have to confront and think of. So that's not to provide a clear answer to your question. It's just to say, you put your finger, I think, on what really is the crucial underlying issue.
So we have 5 minutes, and I know that I have a lot of questions, and I know that you do as well. So I'm going to implore, if you're asking a question, if you could give us a very short question, and we'll get a brief answer, and then we'll be able to get 2 more questions in, and we can head to lunch. So just right here, sir.
Thank you. My question is predominantly directed to Professor Brooks, and I wanted to comment on how excellent your book is, first of all, in exploring this notion of militarism. The question has to do with when you referred in your comments to the need for collaboration amongst our allies and amongst our adversaries to come to agreement. With this emerging militarism that is becoming so predominant, are we investing enough effort in building collaboration and peacemaking, or has militarism become our predominant ethic that sort of actually appease that?
Are we investing enough in collaboration and peace building? No. Short answer. You all heard Jim Mattis' quote when he was testifying when he was CENTCOM commander to, if you guys don't want to fund the development diplomacy, I'm going to have to buy more ammunition. I think our current president thought that was a suggestion, not a warning. No, all right, I'll have to buy more ammunition. But no, I think we have underfunded our diplomatic side for years. It seems poised to get substantially worse. I don't, as you know, you read my book, I care less actually about which agency does what and more about whether we have the capacity as a nation to do the functions that are necessary. So I don't think there is a role for military diplomacy. And I think our military has gotten, the flip side of the militarization of U.S. foreign policy has been the civilianization of the military in many respects. So there are answers other than just let's give more money to the State Department, but I think functionally speaking, we don't seem to be investing, regardless of agency, in those capabilities at the moment.
And one last brief question. Yes.
Psych class arts, I'm Sherman. My question is to you. It seems as though you spoke quite a bit on hybrid, or whatever term you wish to use, exploiting gaps in law, but it also seems as though it exploits a lot of gaps in political will. Now, you spoke a bit on countering the means to exploiting gaps in law. What means can be used to exploit gaps, or to fix the exploitation of gaps in political will?
Boy, that's a great question. I don't know the answer. Political will is like leadership or being a person of integrity. It's easier to describe it than to create it. But I think that these same gaps and ambiguities can enable all sorts of somewhat craven political conduct where you can look like you're doing something without actually doing something, or look like you're not doing something when you actually are. And it can also pose real problems for our theories of democratic accountability to our own leadership, to our own citizens. I don't have a good answer for you other than sort of the old-fashioned answers, which is an educated and informed citizenry, a free press, and strong and robust representative and judicial institutions and civil society institutions can hold political leaders rights sometimes and give them the backbone they might otherwise not have.
Thank you, Mayor.
Before we thank our panelists, I've been asked to keep us on schedule, so when we conclude, I've been asked to encourage us to all rise, proceed directly to the lunchroom, continue our conversations there, and we'll continue the afternoon. But thank you so much again for these wonderful comments.